Well, good morning, everybody. I'm going to make a start because we're already somewhat late. For any of you that don't know, there are headphones and we have English and French interpretation if anybody needs it. But welcome to this small seminar on European property rights and wrongs, which I am pleased to host with my colleague Ramon Tremosa, who I hope will appear to join us very shortly. If I explain a bit what has provoked the organisation of this seminar and why now, I think for many of us who have been members of this Parliament over a number of years, one of the things that we get letters about from constituents in many guises are problems to do with purchasing property in other member states. Historically, it was perhaps the obvious differences between the English and the French systems when British citizens first started to buy in numbers in France, encountering the differences, cultural and legal, between the common law and the civil law system. But as Europe has developed, the problems have multiplied and changed in their type. Also in this Parliament, as a member of the Petitions Committee, we see frequently these sorts of problems, and particularly over the last years, problems particularly to do with the purchase of property and rights to property in Spain, where we have had many petitions, reports, visits from petitioners, and that is something that we want to come back to. But it is not only Spain. If I look at our sort of regular post bag as MEPs, there are several countries that come to the surface. Bulgaria is one, Cyprus is another, all of them giving rise to different but similar problems to do with the purchase of property. And recently, although of course it's not yet a member state, we seem to have had a whole spate of letters from people buying properties in Turkey. So there is definitely an issue there. And I think many of us have felt that as the European Union, we are at great pains to protect our citizens as consumers when they buy goods cross-border through Europe's internal markets. So when you buy a camera or some other good cross-border, or when you're on holiday, you have the full panoply of European consumer law behind you and protecting you. But when you make what may be the biggest or the second biggest investment of your life financially in buying a property, then to an extent you're on your own and you're facing a national legal system with which you are unfamiliar. And of course we have to recognise that it is they are national legal systems that are very attached and important to each individual member state, their traditions and their legal heritage. But how do we deal with this in terms of the problems that are arising, particularly now when, since the Lisbon Treaty, the European Union has adhered to the Charter of Human Rights, a Convention on Human Rights, which contains a right to the enjoyment of property. And many of the people who have had problems, particularly in Spain, have turned to us and said, well, this cannot be correct, that we cannot get a remedy when we have had problems about ownership of property. So in that sense, the time is right to examine the sort of area and see in reality what the possibilities are, but also perhaps to look at some of the practical possibilities of protecting our citizens when they choose to exercise the right of free movement, choose to live in another member state, or to buy a second home in another member state. What can we practically do to make sure that when they buy a property elsewhere, they can feel secure? And we know that there is an ongoing project to link Europe's land registries, so at least we can see who owns what. And there's some interesting work going on there that I believe we should know more about and may offer some practical possibilities. So there we are. There is a brief overview of some of the things that we want to touch on this morning, with a view to, in a sense, starting a discussion about European property and how we get nearer to offering some practical options to stop people getting into difficulties when they purchase cross-border. So that is what we want to attempt to do this morning, and our idea was to start, as I've said, with one of the more extreme examples of what can go wrong, and it has been extreme in terms of the experience in Spain. Now, I was hoping at this point that Mr. Tremosa would have arrived, but I think we're going to have to press on. So what I am going to do is to ask our first two guests, who come from the Embraveria region of Spain, to share with us their presentation, and then hopefully if Mr. Tremosa arrives at some point, then he can intervene or speak after you have finished. So it really gives me great pleasure to give the floor to Brigitte Anquetil and Romain Heiner. The floor is yours. Thank you.
Si vous le permettez, j'aimerais m'exprimer en français.
I'd like to speak French, please, if I may. It's easier for me. I'm Brigitte Anquetil, and I'm here to talk to you about Empúria Brava, a town on the Costa Brava. It was built, well, it began to be built in 1964 under General Franco's government. It was a holiday village with detached houses built on private land. Initially, the idea was not to build on the beach, as is often done in Spain, but slightly inland. They were going to dig canals up to 5 kilometres inland so that they could moor their boats in front of their houses. The parcels of land were sold and registered in the official land registry. Construction permits were issued by the local mayor's office to build these moorings so that boats could be moored. In 1988, Spain voted in the Spanish coastal law. Empúria Brava has nothing. In Empúria Brava, nothing changed. People continued to register themselves in the official land registry. The mayor of Empúria Brava recognised people's rights to moor their boats in front of their houses. But in 2008, Spain decided to change the coastal limit to include all the canals, i.e. going 5 kilometres inland. This meant that it was able to change the land register, the deeds of property in the official land registry. The consequences of this were instant. A 6-metre access strip had to be left free within properties for public access. And here you can see the change of the coastline. In 1960 it went along the beach, 1970 excuse me, it went along the beach, and in 2008 it went 5 kilometres inland to include all the canals. So this law meant that a 6-metre strip had to be left along the canal as public land, and it went through all the properties. Public access had to be allowed within people's land. all the sheds for boats that had been built became state property, in spite of the fact that they had previously been privately owned. You can see the public ports, the private moorings, garages, private pieces of land, the harbours, and the garages within the plots of land. The company that is allowed to use the port took advantage to ask the local government to prevent local property owners from parking their boats there. There were many appeals presented by citizens. They were complaining by the fact that this law was being retrospectively applied, and also this new demarcation of the coastal area, which was taking place 20 and 40 years after the original building of these properties. They also complained against the local authorities and against the expropriation which was taking place without compensation being offered. The economic consequences were terrible. All investments stopped because of the legal uncertainty. Many small companies closed down. Companies maintained boats, houses, gardens, repair companies, nautical services, and so on. Prices dropped, and the crisis was amplified in this area. This issue of legal insecurity affected many people who came from other countries in Europe, and they couldn't understand why entries in the official land registry didn't count and the state could modify them. They appealed to the consulates and embassies of their respective countries and asked about legal certainty in Spain and what it meant for the and why the official land registry could simply be modified. Now, the Spanish coastal law was voted in to prevent large-scale building on the coast and to deal with illegal building on which had taken place in certain parts of the coast. But property owners in Empuriabrava believe that it's not being properly applied in their town. Empuriabrava was built in the 1960s, 20 years prior to the law coming into force, and 40 years prior to the change in the coastal delimitation. They also criticised the idea of this coastal area because, for example, the canals are not the sea. You're not allowed to swim or fish there. Yachts and fishing boats aren't allowed in. These canals have bridges over them. They're simply canals so that people can moor their boats in front of their houses. And they don't believe that this corresponds to the proper definition of coast that is applied everywhere in Europe. Because these canals are an artificial construction, not a natural construction. The real coast should be on the beach, and on the beach there are no constructions, as you saw on the previous slide. The houses are not illegal. These houses were authorized by all Spanish institutions, the land registry, the Generalitat, the mayor's office, and the state. There was a town planning. There was a town plan in 1967. The mayor's office issued building permits, and property owners are continuing to pay land tax on their properties in spite of the fact that they've been declared public land. Mooring rights are also recognised for these property owners. Spain is now a member of the European Union, and property owners believe that the official land registry should guarantee property rights. Basically, these property owners had faith in the rule of law in a European state. How can we explain the causes of all of this? Let me give you some history first. The Marina was established in the times of General Franco, when the state didn't work in the same way as it does now, and the same criteria were not applied. The problems arise from the application of the new law to a situation that was established in the past. The problem is this retrospective nature. The law is being applied everywhere along the coast in the same way, and illegal constructions that have taken place in some areas of Spain, particularly in the south, and Empuriabrava, are all being thrown into the same boat, as it were. The institutions aren't functioning correctly as well. It took the Spanish state 20 years to come up with this new demarcation of the coast, and no one informed the land registry, the notaries, the mayor's office, or anyone, least of all the purchasers. The state says that as seawater comes in, the land in question is public land, but the seawater hasn't reached the land. The fact that the coast was registered as being along the beach, it is illegal to change it and move it. There is also a problem with regards to the justice system. After 3 years of appeals, it's still not been possible to reach court. Now, the more time goes on, the more the consequences become serious, particularly economically speaking. Another important point relates to the enormous commercial interests that often are the cause or at the root of these conflicts. Bizarrely, the most serious cases have broken out where there are major urban and economic challenges. This designation of the coastline has not taken place in the same way everywhere. Some people have been penalised and others have benefited. Foreign companies have benefited from this issue, using their lawyers to achieve interpretations of the texts that benefit their companies. So these issues, together with the discouraging slowness of the justice system, produces corruption and means that specialists get involved in all these areas. The time frames are so long that sometimes political patronage is found for certain companies. For example, in Empuria Brava, the same company sold the land. It's the company that sold the land in the 1970s that is benefiting now thanks to the new law. They're trying to take the land back so that they can rent it out or sell it for a second time. This company is using the weakness of the system and the difficulty that property owners have in defending themselves. This is an onshore company that is involved in other cases of land corruption. In fact, the changing of the coastline was used as a pretext to take back the mooring rights that had already been sold. Urban speculation is also having an influence. The markets for designating land and producing construction projects are utterly intransparent, and this is causing problems for property rights as well. This is particularly the case in addition, in the countryside and in small villages, a lack of education and the amateur nature of politics and administration is causing problems. Different rules and a lack of common regulations between countries mean that corruption does take place. That's a personal opinion. To conclude, we believe that we need to have an equal definition of property rights. There needs to be a convergence between the different kinds of law, whether Roman law, Germanic law, and so on, because the principle of property is not the same everywhere. Becoming a member of Europe should mean the same guarantees are available to everyone. The principle of non-retrospective application also needs to be taken into account. Situations that were legal in the past need to remain legal, as in Empuria Brava. The same conditions for land registries to function should be ensured, to ensure that all European Union countries act in the same way. We need to have legitimate faith in the institutions and the rule of law. There needs to be a clear definition of coastline, which ensures that coast is simply along the coast. There needs to be more legal information provided. when people need to defend themselves against powerful administrations, the path can be long and costly, and this needs to be dealt with as well. If there are disputes affecting a large number of people, an independent European ombudsman needs to be involved rapidly. This would mean that the courts didn't get clogged up with these issues, and the serious economic consequences could be dealt with through a rapid resolution of the problem. Those involved, of course, need to be impartial and as independent as possible. They also need to be they shouldn't be local actors. There needs to be more transparency in the urban market, and there needs to be more citizens' participation in everything to do with urban planning. The criteria between countries need to be harmonized to prevent dysfunctioning and abuses, and there needs to be more monitoring of administrative and political corruption. Let me conclude by saying, well, we're a very European family. I'm French, my husband is German, my children are Spanish, so we are the prototype European family. We have benefited a great deal from European Members of Parliament's efforts on our behalf, and we'd like to warmly thank you for the efforts you've made. We hope that what I'm saying here will enable you to defend property owners and improve the system for the future. On behalf of the 3,000 members of the association that I represent, I would like to thank you for inviting us here and for your work on our behalf. We would like to invite you to visit our beautiful region. In spite of the difficulties that are currently in evidence in Spain, it is a beautiful area. We have ours is a European village where all nationalities in the European Union are represented, and we would like to cordially invite you to visit us.
Thank you so much indeed. I really understand. Thank you so much for sharing all this with us, because I think it resonates so much with what we hear and read so often as MEPs from our constituents and others that write to us. We have created perhaps too great an expectation of Europe, but then I don't think we can have done, because people want an answer. They have moved about and exercised the right to free movement, and they have a right to expect a certain system that gives legal certainty, that gives access to justice when things go wrong. I know we did, certainly as a petitions committee here, want there to be an ombudsman's type system, as you described, to try to deal with some of these problems more speedily. And the idea that within Europe you can have a system that allows a retroactive law that doesn't deliver compensation goes against all that most of us have ever been brought up with. So I think starting the discussion we're starting today, and starting with your contribution, is really to see how we can move beyond this and improve it. But thank you so much. And now I'm really pleased to welcome my colleague Ramon Tremosa, who will now say a few words. The floor is yours.
Thank you very much, Diana. Good morning to everybody. Excuse me for the delay, because my flight departed on time at 6:30 from Barcelona, but here in Brussels the traffic jam did not allow me to arrive at 9:10 to talk to you. Well, I am a member of the European Parliament, coming from Barcelona. I am elected by the Catalan coalition, which is formed by the Liberals and Christian Democrats, that now we are ruling the Catalan government since November of last year. And we always have been frightened for this specific case of Empuria Brava. I know that in Spain there are several cases which are different, but we are a Catalan coalition, and we are focused on defending our case of Ampuria Brava. And this is the reason why, for instance, 4 months ago, I promoted an initiative, a written declaration with other members of the parliament, from the Green group, from the Conservative group, and also from the Freedom and Democracy group, just to put on the agenda that there is a specific case in the Costa Brava, which is Ampuria Brava, that you have been now informed more in detail. Well, I think that without defending the property rights, there is no freedom. And I can recommend you one of the best books that I have ever read, which is written by a British writer, Richard Pipes, which is Property and Freedom. So in this case, I recommend you this book. Of course, we could talk about John Locke and other authors coming from some hundreds years ago, but I think that much more interesting is this book. Without defending the property rights, we will not have freedom. This is my things about this. And I also wanted to come here to say that we have to make a very big effort, because we now have in Europe a wave of new political behaviors which are dangerous in this respect. For instance, talking about Spain, I think that Felipe González, who was the former prime minister from the socialist government 15 years ago, he was much more sensible to this question than the current prime minister that we have now, Rodríguez Zapatero. Felipe González, I remember him that 15 years ago, he usually traveled to Sweden, to Germany, to Denmark to learn about the reformist social democrat Nordic countries. And he was very influenced by this kind of social democracy. But now what we see in the Spanish socialist government, in several Spanish ministers, and of course in Mr. Zapatero, is that he is much more closed to the South American revolutionary populisms than to the reference that the Socialist Party has had during a lot of years in the center and in the Nordic countries. So this is, and I know I cannot talk about other countries in the European Union, but I think that in Spain it is very clear that we have our Socialist Party, the Socialist Party in Spain has moved, has made a travel to the past that for me is very, for me it's not a good evolution. So, and for instance, it is, we are talking not only about property rights. There is other main aspect affecting to Spain, which is the photovoltaic industry. In 5 years ago, this Spanish government wanted to become the world champion leader of the new renewable energy sources of energy, and the Spanish government gave very good incentives to this kind of industry to attract investment for all over the world, and he did it. But now, because of the crisis, 1 year ago, he has cut with retroactive effects all the subventions that gave to these investors. So how can we plan in the long term for this kind of investments that we need 30 years to recover these amounts? How can we cut in 2010 some benefits that we have given 4 years ago in 30 years term? So it's a very bad precedent, and also the Commissioner Oettinger has been very active denouncing that it was a very bad precedent in the European Union, that such a behavior like this could not be punished by the electors, by the voters, or by other governments, because it is inside the European Union that we have a very bad precedent. So this is the reason why I have came here this morning, just to tell you these few words. We know that these issues, in the case of Spain, have to be resolved at local level. And I think that the good results of our coalition, also in the local elections that we had 3 weeks ago, that has been very good for our coalition, is influencing also on this. But I think that it has been very important, the pressure that from the European Parliament has been done over the Spanish minister, over the Spanish government, and it has been very useful, the pressure that the owners and the affected people of Empúria Brava in this case have been doing in the Parliament, in the media, and also at a local level. So I think that it has been a good combination. And I have a good news to finish my intervention. Yesterday, in the main Catalan newspaper, appeared a good news. It seems it is a promise, and I cannot give so much trust to the promises that the current socialist government is doing now in Spain. But in La Vanguardia yesterday appeared new that it was for me very good. That it seems that from the Spanish Ministry of Environment, it seems that there will be an exemption to the coastal law, Coastal Act, related to Empúria Brava. But it is not definitive, but it seems that all this pressure that we have done at different levels, it has become effective. No? It seems to be effective. But I know that it may be result of the last elections that we have had at regional level and local level. Now the socialist government is weaker and maybe is much more sensible to these issues. But for me, it's a very bad precedent, and this is why I have been very active in trying to help the affected people of Empúria Brava. And of course, I will be in the future ready to help in any other case that we have in Europe, because this is not good news for the future of Europe that we are here discussing these kinds of things. Thank you very much.
Thank you very much. And I think it's good to make that linkage that sometimes we perhaps don't dare to make, that clearly the attitude to property and the way it is property rights are dealt with does very often have a political underpinning or a political linkage, which, as you say, is quite worrying if it goes in the wrong direction to that which most of us in most of Europe are accustomed to. I wonder if I might, at this stage, call upon David Lowe, who is provides secretariat to our Petitions Committee and has had years of experience of dealing with many of these property cases. Perhaps just to share with us a general sort of overview of the types of cases we've had and where you think we are now with this, before we go into some more, I won't say technical, but more expert sort of presentations.
Thank you, Diana. Speaking as a member of the Secretariat, I do so I should be very careful in my pronouncements. I'm not involved in the political activities of the Parliament, but I've been asked really just to contextualise a little bit what the importance of property is for members of the Petitions Committee, for the Parliament, and try to describe to you as best I can the way in which I believe the Petitions Committee reflects this very fundamental concern of people from many different European countries about their respect for their legitimate property rights. I think for the Petitions Committee, and indeed for the European institutions, there's rather a dilemma, because the treaty itself excludes the system of property ownership from the field of EU competence. And right from the start, therefore, the Petitions Committee had to be very careful about how it approached the particular issue from the environmental aspect, from the public procurement aspect, from the free movement aspect, from the right of establishment aspect. But also, we had a reflection about what does this exclusion clause mean when it talks about the system of property ownership. What people are coming to us about is their right to their legitimately acquired property. And it seems to many in the Petitions Committee that that is not exactly the same thing as a system of property ownership. And it's also on that basis that we perceive that both in the Charter of Fundamental Rights and also in the European Convention of European Rights, it is very clear that people are to expect a right to their legitimately acquired property. And when they are to be, for whatever reason, divested of that property, they're not divested of it under any old circumstance. The people that take decisions which deny people their property rights have to do so according to the jurisprudence of the Court of Justice, with due regard for compensation, with due process, and also it should be in the public interest. In our experience, and we've been dealing over the last 2 legislatures with hundreds, literally hundreds of petitions dealing with this matter, some of these petitions signed by many thousands of people, we've been confronted on a regular basis with this most controversial of issues. I think it is clear from what Diana has said, and indeed from what Mr. Tremosa has just mentioned about the situation in Catalonia, that the bulk of the petitions we receive come from people who have property in Spain. A lot of those people are from Germany, from the UK, from the Netherlands, from Belgium, from France, from different northern European countries, but have taken the decision and made the choice to settle in Spain, to buy property in Spain. But it may surprise you to learn that most of the petitions we receive are actually from Spanish people themselves, because they have been no less deprived of their property rights than people from all the other European countries with which we're concerned. And I think it's as a result of this feeling that this wasn't just a problem of foreigners, it was an intrinsic problem within Spain that led the Petitions Committee to organise 3 fact-finding visits to the country, to write 2 reports, including one very substantial report by Margaret Auken, which was adopted by the European Parliament in the last legislature in March, on the 26th of March 2009 in Strasbourg. And you can retrieve a copy of the Auken report from Parliament's website, because that makes quite explicit both the considerations that the Petitions Committee has had in relation to EU competence, in relation to applicable law, and also in relation to what we believe ought to be done by the Spanish authorities, both at national and in the various autonomous regions about that. Parliament, there's a number of very important paragraphs which I shouldn't really quote to you, but Parliament considers that the obligation to cede legitimately acquired property without due process and proper compensation, and the obligation to pay arbitrary costs for unrequested and often unnecessary infrastructure development constitute a violation of an individual's fundamental rights under the ECHR and in the light of the case law of the European Court of Human Rights. And that was adopted by a very considerable majority within the European Parliament. I think we have, therefore, because this is where the petitions have come from, largely focused our efforts on the problems faced in Spain. We know the situation in Spain, we know its serious financial problems that it is going through, the enormous levels of unemployment which have resulted from precisely the property bubble that even in our reports we were talking about 3 or 4 years ago. And I think that now it really is urgent that, as Diana has referred to, some system of legal certainty is established for property owners and for property sellers in Spain, so that people that have bought property legitimately, have followed the rules, have gone through local lawyers, they have used the local authorities, they have had authorization. These people cannot now be divested of their investment, which is, after all, the biggest investment most people make throughout their lives. I think the links between property and freedom are, personally, I would obviously very clearly recognized. I think there are other links that are perhaps less pleasant to think about, the links between construction industry and the corruption which has been manifest in Spain, and which, thankfully, the Spanish justice system and the courts are now beginning to come to deal with much more than was the case in the past. And a lot of the petitions that we receive are from people that believe that they themselves have been victims of this widespread and highly prevalent construction in many municipal authorities and in many regions. I'd just like to say, with respect to other members here, that it is true we've also looked at property issues even in the candidate countries of the European Union. We've looked at the situation in Bulgaria. We've looked at the situation in Cyprus, where, for some reason, the Commission has now actually launched an infringement procedure about property issues in Cyprus, whereas it doesn't seem capable of doing that in relation to Spain. And I think that it goes without any shadow of a doubt that the priority that the Commission, that the Petitions Committee and Parliament itself has attached to this issue in the recent years has been precisely because people have been coming here to appeal to us through the petitions process because they've had no response at all in their own member states, and particularly no response within Spain. And I think that also demonstrates the capacity of the European Parliament and its members to listen to what citizens are saying to them. And as this seminar is showing, and as I believe the Auken report and other actions the Parliament has undertaken, I think it demonstrates that Parliament is determined to do something about it.
Thank you very much indeed, David, and thank you for all you do, sometimes behind the scenes on the Petitions Committee, and I think that gives us a very good overview of what the problems are and where we need to start, perhaps, to look for solutions. And that's what we want to do now, to move on, as it were, to think about some of the possibilities for European property rights in the future, to examine some of the possibilities. Some of them may go too far for some of us, some of them not far enough, but at least to start a discussion about some of the actions we might look at. And so it gives me great pleasure to introduce two speakers from the University of Maastricht who have been very active in this area. And firstly, Dr. Bram Akkermans. The floor is yours.
Let me see if I can get the PowerPoint to work, and otherwise I happily do without. I have no idea which is mine. No, sorry, I can't see, I seem not to be able to find my... Did you put... Sam? Sorry.
Don't worry.
Yeah, no, I can do without, it's fine. So, ladies and gentlemen, while Sam has a look at, let me start, you know, for reasons of time.
Do you have your...
Yeah, it's somewhere. Let me start by congratulating Mrs. Wallace and also Mr. Tomosa on the effort, you know, to pay attention to property rights in the European Union. And it's in my somewhat young career, but let's say over the last 10 years, we've worked in academics and in academia. We've worked really hard on these issues, and it's very nice and for us very it's satisfying to see that there is now European attention pay to the, thank you so much, European attention, and that the European Union is really paying attention to these issues that we have been paying attention to for such a long time already. There's something wrong with the color, but it will work nonetheless. My challenge for today is, I think, and I was asked to introduce let's say the issues at the European level and to describe very shortly what exactly activities the European Union already undertakes in the area of property law, and to what and to provide that, let's say, a small outlook for future and for the future developments when the European Union touches on, or whether the European Union could touch further on issues of property law. And then Professor Van Erp will take up and talk about issues of private international law and share his wisdom on this with you. Now, I think it's very strange, if you think about this, that property law is not something the European Union deals with at the outset. And as you said, rightfully, I think the freedom of ownership underlies, that idea underlies the whole idea of a free market economy. And if you look indeed at let's say the new member state and the former socialist countries, this is exactly where they have been struggling in the transition period after the fall of the socialist and communist regimes. From that point of view, it's very strange that the internal market, the European internal market, that's so much based on economic cooperation and all these freedoms of movement, that property law is not something that has been included at the outset. Now, of course, there's Article 345, and I cannot resist, because you addressed this so directly. We could not disagree more on the explanation of that article. And my colleague Evelina Ramakers and I have published on this, and we've done extensive research on what exactly the meaning of that article would be, and we would respectfully submit that it does not mean at all that the European Union should not act in the field of property law, and rather that this is a competition law-based article that says that the treaty shall be neutral as regards to whether a company is owned, or the shares of a company are held by the state or held by a private person, and therefore the idea or the process of nationalization of companies, which has nothing to do with property law, is to that the treaty at least takes a neutral stance. But this is our that would be our viewpoint, and I think this is further submitted or further grounded by existing case law in the area of property law, but also existing European legislation in the area of property law. You can think about the return of cultural objects, stolen cultural objects, or the financial collateral arrangements directive that deals with property law aspects directly. So it's very interesting, and I want to make this my let's say my task for today, to provide a little bit of a translation from these practical problems that we're now experiencing to potential solutions, and potential solutions that the European Union takes and may take in the future. Now, if you consider buying and the purchase or the acquisition actually of ownership of land in another member state, then it will come as no surprise, I think, to those of us who deal with these issues, that actually 3 out of the 4 freedoms are immediately affected. If you buy land in another country, in another member state, we are sure, this is not a question of debate, that this is a capital investment. The European Court of Justice had said so, and there's a list to which the acquisition of land certainly falls under that. But also, if you buy a house, let's say a holiday home in another country, and you rent it out, or you lease it out for most of the times, that makes you a service provider. And therefore, it also would fall under the freedom of movement of services. Or if you hire someone to take care of the house, or a gardener, you are the receiver of services. So also the free movement of services affects this. And of course also, I think this is the most obvious one, that also the free movement of persons, that the freedom of establishment falls under, so that those aspects of property law also fall under the current application, let's say the negative integration, as we call that in academia. And there are cases of the European Court of Justice on this. There are cases that deal with this under the free movement of capital, under the free movement of services, and a little bit under the free movement of persons. So let me, in the end, come back to that. But let me introduce one term now that will, I think, for the rest of all the legal experts that will speak, it will continue to pop up, and this is the lex re cite. And lex re cite is a rule of what we call private international laws, or conflicts of law rules. And it states that the law applies where the object is situated. And it's the way in which we lawyers address issues, in which we decide, on the basis of which we decide what is the applicable law. And we will say a lot, I think. Everyone is going to say a lot about lex re cite, because this is the current status and the current legal, the current field that we have to deal with. And, well, let me leave it at that for the moment. Now, let me focus to start with at the acquisition of property in another member state. Then I think there are two aspects that are of relevance. And there's a contractual aspect. And I think the European Union has been very active in the contractual parts of it. And there's a property aspect to it. And this distinction between contracts on the one hand and property on the other hand, this is a distinction that is not necessarily made in each member state. And some member states concluding the contract for land creates property rights. And this would be, as far as I understand English law, this would be an English law situation, but also a French and perhaps, and to a certain degree, any country that bases its legal system on French law. But there are also countries that follow a more, let's say, Germanic or German-inspired tradition, where there's much more separation between the contractual aspects on the one hand and the property aspect. So let me divide, therefore, let's say, the contributions of the European Union into contract and property. Now, when we talk about, and we've talked a lot already about consumer protection, then this always focuses on the contractual aspect. As far as the consumer legislation, the current EU consumer legislation exists, this focus on the contractual aspects. And when I prepared for today's seminars, I realized that this is, of course, very important, and I will mention those acts of European legislation that I think have an effect on this. But we should realize that when you're buying a piece of land, or when you're buying a house in another member state, you are not necessarily buying this from a professional party. Instead, you might, very often, actually, be buying from another personal party, from another private party. And that means that this would be a C2C situation, so a consumer-to-consumer situation, where all this beautiful consumer protection acquis would not necessarily apply. And you could, of course, say, well, you will deal with a real estate agent or other professionals, but those will usually be intermediaries. So the contract that you eventually conclude will be between two parties at the same level. And this creates, at least in my view, to a certain extent, creates some difficulties of the current European approach. Because this European approach, particularly in contract law, is very much based on what law and economics or economists call information asymmetry and unequal bargaining positions. So where there is inequality between the parties, then European legislation interferes. So what can you think about? Well, you could think about then, for instance, the current existing legislation on misleading advertising, and current and existing legislation on unfair commercial practices. Particularly the Unfair Commercial Practices Directive is very, very important here, because it was one of the first consumer law directives that explicitly said that land should be included, and therefore that the directive in full, which is a full harmonization directive, it applies in full to at least the contract for the acquisition of land. What also exists is there's legislation in the area of timeshares. And also the timeshare directive that has now been, well, let's say fairly recently been renewed, also concerns those contractual aspects. So if you are concluding a contract to acquire a property right or a contractual right, that depends on the legal system, that offers you a timeshare or timeshare equivalent interest. Now, particularly these two, so these three, misleading advertising, unfair commercial practices, and timeshares, they offer what you could call pre-contractual remedies. And I think there are two types of remedies that the consumer acquis offers. It offers pre-contractual remedies, particularly in the form of so-called information duties. And these information duties, the European Union or the European Union legislation addresses this information asymmetry. So the idea that you don't know who your party is, who the other party is, the specification of the object, of the money involved, if this is for mortgages, for instance, the interest rates involved, calculation examples. So by law, you force the trader to provide information to the buyer to resolve, at least in part, some of that information asymmetry. But you also have, and that includes now also the timeshare directive since the new version, you also have rights of withdrawal. And the rights of withdrawal, they connect to this what we call the cooling off period. So the idea that once you have concluded a contract, you should give a consumer time to think it over and perhaps return or revoke his decision to be bound by the terms of the contract. And a right of withdrawal, which is generally unknown to any legal system, it's a very European law remedy, allows you to pull back from the contract. And this, I think these are the two angles of attack that the current existing, well, say, consumer acquis takes. So what else is there? You have the timeshare directive, you have the package travel directive, which you should not forget because it concerns the possibility, not necessarily for the acquisition of ownership, but it does apply to leases and leases of land, which are in some countries only contractual, but in countries like England, they are property rights. So a lease creates a property or proprietary interest for the lessee. With a little bit more controversy, there is the unfair terms in consumer contracts directive that contains a very famous blacklist of terms that you cannot have and a so-called grey list of terms that might be suspicious. And it protects the consumers against, well, very unfair terms in the terms and conditions. These general terms and conditions that no one ever reads, not even research shows when you're buying property. I asked my father, who in my view is always the standard consumer, whether he, upon conclusion of his mortgage contract, had actually read the terms and conditions of the bank. And he looked at me as if I was crazy. Of course he had not. So the unfair terms, and there's been some debate about this, whether this would apply to land, but generally we say yes, also the unfair terms directive applies to immovables. Then there's an angle that the European Union takes when contracts are concluded under, let's say, certain circumstances. So the distance selling and doorstep selling directives, also these apply to the acquisition contracts. Although this is a little bit more controversial, and particularly the doorstep selling directive itself explicitly states that it does not apply to the acquisition of immovables. Now, without going too much into detail, the European Court of Justice has dealt with this, particularly in the area of German cases where the acquisition of ownership was sold to a linked contract situation. So where someone would come on your doorstep and you would buy 3 contracts, the acquisition of ownership, the contract for a loan, and the providing of a property security right, like a mortgage. And, well, afterwards, I think years afterwards, we discovered, or they discovered, that this is a situation of doorstep selling and that therefore the consumer in this situation should have a right of withdrawal from the contract. And the Court of Justice then says, okay, so it only applies to one of the 3 contracts, but it is for the national court to decide on the basis of the principle of effectiveness of European legislation to decide whether the right of withdrawal should also have effect on these property contracts. So it makes sense, at least, that to say that to a certain extent, and I'm sorry to be so short, but I hope there will be a written version later, and then I will go much more into detail about that, that at least to a certain extent, also distance and doorstep selling would have an effect on the acquisition of property rights. And then finally, I want to mention the new mortgages proposal, because I think this is very interesting for us all to have a look at. And although it does not concern directly the acquisition of ownership of land, it does affect it, of course, to a very large degree, because most of us, not all of us, but most of us need to go to a bank and obtain finance to buy property in another member state. And if we do so, then the proposal for mortgages, which plans to offer total new specific rules on marketing, so the pre-contractual phase, and it also proposes a right of withdrawal from a mortgage contract, which I think is an innovation, and we have to think about this, what this means for the proprietary, for the property law aspects of that. But it's certainly well worth to take a look at. So this is I think the more modern directives take a combination of the pre-contractual and post-contractual approach. Now, like I said, in consumer-to-consumer situations, which in my view would happen a lot if you buy an apartment in Madrid, let's say I'm Dutch, so I would want to buy property in Madrid or in Barcelona, then not necessarily I buy this from a construction company. And even if I buy it from a construction company, I think we have to be careful here, because construction contracts are a very special regulated part of contract law, and not automatically the whole consumer acquis and the consumer protection acquis will apply in those situations. I think some member states at least will try to avoid this under the, the semi-special status that they give to construction contracts. It's just something to take into account. Now then finally, a little bit about property law, about the property law aspects, and as you would guess from my approach, I would argue that we should at least think about moving also in this area. And although I realize this is controversial, and I realize that there are many political aspects contained in this, I'm wondering and I'm submitting that perhaps if we really want to solve these issues, then we should not be afraid to look at, for once, the possibilities to actually go into property law situations. And then we will be confronted with an enormous amount of complexity. There's nothing you can do about this. In contract law, there are many, many more similarities, but Professor Van Erp will address this. There are many, many more similarities between member states than there are in property law. And we are very much, unfortunately, still very much confronted in property law with the big divide between the civil law system, so the continental European tradition, and the English tradition. And although I fully agree with Mrs. Wallace that, of course, the problems are now much more diverse, that when it comes to regulating, when it would come to regulating property law issues, we would first have to tackle this civil law versus common law. There's the Nordic legal systems that we do not really know how to deal with, because at least the Nordic systems submit that they do something completely different. And there's not much research, also not in academia, done in this area. So another question would be, would the European Union have competence? Yes, I think they would. And I don't see Article 295, sorry, so that's now 345 as an obstacle. I don't see a problem of using Article 114, that's the internal market article, so the old Article 95, as a legal basis for this, exactly because it concerns the freedom of ownership. And exactly because it so much connects to the free movement of persons and the free movement of capital. And I will agree and I will submit there are difficulties there. So finally, before I give the floor to Professor Van Erp, a little bit about the human rights aspect, because I was asked to address this specifically, and I think it's very important to say a bit about this. Now, I'm sorry to say, but I'm very skeptical about the possibilities to use human rights protection, particularly Article 1 of the first protocol of the European Convention on Human Rights, that guarantees the free enjoyment of possessions. The problem with this, with the whole European Convention on Human Rights is that it offers let's say, a post-event protection. So once a member state or once a government decides to act, it will give you a right to compensation. But it will not, as far as I understand the article and as far as I have ever done research, it will not contain, it will not allow you to get an injunction to prevent something, to prevent a member state from interfering with your property rights. And of course, the article entitles you to compensation. And there's a so-called fair balance test that the the Court of Human Rights employs, and they will decide whether, on the basis of that, the government has taken, and that can also be a local government, have taken a good decision, a rightful decision, and whether or not you should be allowed to compensation or not. But it doesn't allow you to get an injunction to stop the government from interfering. So you will lose your property right. The only question on the basis of Article 1, that's how I would explain it, is that you can get compensation after you've lost your rights. And there is some movement of the European Court of Human Rights towards the agreement and the inclusion of so-called positive burdens for member states, so that on the basis of that, the member state must actually take action to prevent you from, or to prevent interference with your property right. But until now, those have basically been prevention of natural disasters. There's a very famous Turkish case of a landslide, so an explosion on top of someone living on a garbage belt, and an explosion at the top, and therefore a landslide that destroys the home of this person. And the European Court of Human Rights saying, okay, but perhaps you should have prevented this from happening. But it's not like in our, a very unfortunate Spanish case, I don't think it will be very helpful. So, just to conclude, there is European legislation. It tackles this business-to-consumer side very much, and it tackles the contractual side. But there is no, at least as far as I'm aware of, current activities that really go into the property law aspects of it. And the advantage of doing that would be that it would apply across the bank. So it would apply to all situations, whether you are buying from a professional sales party, whether you're constructing your property, you're just buying land and constructing on it, or whether you're buying existing property. But let me leave it at that for now. I will give you my contact details, and so will Professor Van Erp, I think, so that we are very happy to answer questions also at a later stage. Thanks.
Thank you so much for starting the overview. I'm very tempted to say it's the normal sort of mix and muddle that we find at European level, that we have intervened in some ways, but it's not as coherent as we would like. And so we have to see what can be done. Please, Professor Van Erp.
Thank you. Well, thank you very much, Mrs. Wallace and Mr. Tremosa, for bringing us together. And thank you very much, Bram, for the first part of this talk. Ladies and gentlemen, I think we heard a frightening example of how things can go very wrong, and I'm convinced that something should happen here, absolutely. I also think that perhaps a second wave of problems that might be coming to the European Parliament may concern pension rights. People losing pension rights, claiming that they own existing rights, and that by changes in rules on pension rights, they are expropriated. So I would not be surprised if that would be a second wave of problems. As Dr. Akkermans already explained to you, the European Union does have competence in this area. Article 345 does not prevent intervention from the European Union in the area of property law. It only says that decisions on nationalization and privatization are a matter for the member states, as we all have seen during the banking crisis when member states nationalized banks, and the European Commission did not intervene with regard to the nationalization as such, but did intervene with regard to competition. Now, as to what can the European Union do, what can we do at a European level? We have two aspects to this problem. There is, first of all, of course, the public law aspect of the protection of ownership as a fundamental human right. And that is what Dr. Akkermans also talked about briefly. That is generally an ex post protection. Things have already gone wrong, and people say, my property rights have been infringed, I need protection, at least I need compensation. But what we are looking for is solve the problems before, perhaps, they result in these dreadful consequences that we've seen now. So what can we do ex ante in the area of property law? And that is not easy. As you say, it is not easy. In the area of contract and tort, in fact, European legal systems share quite a lot. But in the area of property law, we do have to start first by saying, well, what are the differences? Because the differences are huge. Of course, it is, first of all, common law and civil law. The civil law approach based on Roman law, a unitary concept of ownership, there can only be one owner. The common law, at least in theory, still rooted in the old feudal system, with no concept of ownership as known on the continent. In the area of land, freehold, but is freehold the same as ownership? I would say from a functional analysis, yes. But still there are huge differences. But also you should not think that it is just the civil law, because also in the civil law tradition we do have enormous differences between the way French law approaches property law, German law, or as Dr. Akkermans already hinted at, in the Scandinavian legal systems. The problem already begins with, but I will not go into detail, already begins with what you call property law. For an English law, your property law generally is land law. But for a civil lawyer, it depends upon whether you come from France or Germany. When you come from Germany, property law only deals with physical things. In French law, you can also deal with immaterial things. So the word property by itself already is problematic. So when we move into the area of property law, we will have to do it carefully and slowly, not to create more problems than we try to solve. We have to, but I will not say that it is impossible. When you study the various property law systems in Europe, you discover that they do share quite a lot of, let's say, basic elements. They all have in common that the number and content of property rights is somehow limited. This depends upon the particular legal system, but that is a common aspect, a characteristic they share. They also share principles concerning publicity, that you should know about property rights, that you should be informed. The problem here, however, is, and that is what you can see in practice in many countries, not just in Spain, are the public law limitations on ownership, not the private law limitations. Servitudes are registered, usufruct is registered, mortgage is registered. That you all can find in registries. That's not the problem. The problem, particularly in the Spanish case, is public law limitations no one knew about. And that suddenly came up. So we talk about registration of public law interests. That is a major problem area here. Now, property law systems have other characteristics in common. Those are fairly technical, but one is, for instance, that an older property right has priority over a younger property right. But then again, I talk about problems like, well, what is the relationship between a servitude and a mortgage, or a mortgage and a usufruct? But again, here we deal with public law limitations. Now, based on these common characteristics, using a more functional analysis, so say, well, let's not talk for a long time about, well, ownership on the continent is dominium, and ownership for a common law, it doesn't exist, but there is freehold. When we approach the problem from a more functional viewpoint and say, well, in fact, what do all systems have? They have at least one right that gives on a person the most extensive rights concerning an object possible. And for an English lawyer, that is freehold. For a civil lawyer, that is ownership. When we approach the problem from that side, from a more functional viewpoint, I think we can move into this area. We do, however, then have to develop a European property law. And here again, we can learn quite a lot from contract law and tort law, where we have a whole gamma of directives, regulations, and so on, and then afterwards had to discover that they were incoherent, that they gave different levels of protection. Some were maximum harmonization, some minimum harmonization. Periods differed. That is what we are now trying to solve through the common frame of reference. We should avoid this whole set of problems. When we enter property law, we can learn from past experience. So do it right immediately. It doesn't mean to say that we would have to Europeanize the whole of property law. I don't think that is necessary. It would also be, I think, impossible. Because if you start unifying a particular part of property law at the European level, well, you know where you begin, but you don't know where you end. One example is the proposal for a so-called Euro mortgage, to have one mortgage law for the whole of Europe. That Euro mortgage idea is based on the German Grundschuld, and it makes it possible that you trade in mortgages by trading in documents. But in fact, if a land registry issues a document, that land registry has to be certain that that document is correct. So you presuppose that that land registry is able to guarantee the correctness of the document, and several land registries in Europe are just unable to do that. They have not been set up as such. So this Euro mortgage proposal would in fact mean that in some member states, when the proposal would be enacted, the whole land registration system should be reformed. That was not foreseen, but it is a consequence, because one problem is connected to the other. And we should be very careful about that, because property law systems tend to, well, be formed in such a way that if you change something here, you change things in other places. We have to move carefully. But again, that doesn't mean to say that we should not move, but we should know what we're doing. How could you move? What is possible? Well, I think, first of all, we should try to avoid private international law problems. So have uniform rules on private international law. Now, with regard to land, it is generally the lex rei site. Everyone agrees. But property law, of course, also comes up in matters of matrimonial property and the law of succession. And the European Union is not acting in those areas. So private international law, that's one. We should also think about connecting registers. That is already happening in the ULIS project, where land registries are connected. So sitting from behind my office in the Netherlands, I can look up details on houses, land in Spain, for instance, or the United Kingdom. But getting the information in your screen, on your screen is one thing, doing something with it is something else. Now, the land registrars are going to talk about the so-called Crobeco project, cross-border transfer of land. And that is a project that was started by the European Land Registry Association, saying, we now have this information, let's do something with it. Dr. Akkermans and I are advisors to that project from the Dutch side, because there is a pilot project, Netherlands-Spain. And we encounter numerous problems that we are trying to solve. And again, one of our major problems, again, concerns the public law limitations. So I think it keeps coming up that perhaps registration systems concerning public law should be an area where Europe should look at. Make that more transparent, more open. We should take into account, of course, that we can only act in the interest of the internal market, so cross-border. But what is cross-border in the Eurozone? As Dr. Akkermans has explained to you, freedom of capital is involved when you buy a house. And in the Eurozone, the capital market is European by definition. So simply by buying a house, concluding a mortgage agreement, means that this is cross-border. And again, that is why I think that Article 345 here is not, how to say it, a problem in itself that should stop us from thinking about European solutions. I would like to leave it at this point because I've got several speakers following me, and Mr. Akkermans, in fact, explained very clearly, I think, the possibilities that contract law offers, but also the limitations that European contract law offers. It is now good that we hear from practitioners about the practical problems and possible further solutions. Thank you very much for your attention.
Thank you very much indeed. I think we're going to have a quick change of personnel. If I could ask Professor Sparks and Andrew Walker QC to join me up here, and then we can move on. Thank you very much. I'm sorry we have to move forward, but time is pressing against us now. Thank you. Thank you. Mr. Tremosa is going to leave us now. Thank you so much. Our next speaker is Professor Peter Sparks from Southampton University. So we're going to start to get a common law view on this now. So, Professor Sparks, the floor is yours.
If I can just get my PowerPoint.
I think it's going to test our colour blindness or not. But anyway, if we can manage.
Yeah, sure. My partner, Helen, has always supported my career ever since we met at university. When I started writing on English land law, she told me that I'd chosen the most boring subject in the world. But she completely revised her opinion when I told her that I was going to write European land law. She was absolutely incredulous and said I'd taken the two most boring subjects in the world and put the two together. Of course, today's audience may not entirely agree with that opinion, and I hope not. I'm going to appear when I speak in England, I normally appear as Professor Peter Sparks, an expert on English land law. But when I appear in Europe, I appear as Professor XYZ. I'm not married and I'm not a footballer. If people in England will understand the reference here. And I appear in this way because it's career death in England to appear as an expert on European property issues. I'm going to assume from what Bram and Chef have said that there is clearly a European property law. I'm going to confine myself exclusively to land. Lost my PowerPoint completely. And I'm going to assume that at present the property law or land law of Europe is very narrow, and I'm going to discuss, therefore, whether there is the potentiality to get to a much wider scope or not. Now, this slide is supposed to represent a timeshare punter who is in Spain, a timeshare punter who is in England, who is buying a timeshare property in Spain. What we have, therefore, is the cross-border element which is necessary in order to bring into play a European scope. And the reason that Europe took an interest in timeshare was the issue of volume. It was the volume of transactions which eventually created a European scope. I think, however, that one has to draw a clear differentiation between the marketing aspects of timeshare and the substantive law. It seems quite clear that marketing is within the European remit, and indeed that Europe has effectively nailed the problems of marketing timeshare. That covers roughly 3/4 of the complaints which the European Commission receives. On the other hand, the substantive aspects of timeshare in Europe are not clearly covered by the European remit, and that is things like the actual ownership mechanism of the timeshare and the problems of management and service charge. And that covers roughly 1/4 of the complaints which the European Commission receives. So I think we can draw the message from that that there is a European scope, but there is also a very significant European limit. And it is very unlikely that Europe is going to go on to create a comprehensive European land law. It shouldn't do so. And the question is primarily, as the previous two speakers indicated, where do you draw the line? Now, the next slide that I'm possibly going to show you in just a second, or possibly not going to show you in just a second, is a list very much like the one that Bram indicated at the beginning. It's not your laptop. This is the European Parliament. Come.
We're too attached to our blue colour, I think.
Yes.
I'm going to have a list here of, thanks, which runs from a holiday in a hotel at the top of the list, down to a straightforward purchase of land at the bottom of the list. And I suggest that you can't exclude the whole of land. Somewhere down that list, holidays, timeshares, renting holiday cottages, down to mortgages and purchases, somewhere along that list you have to draw a line and say below it is outside the European remit, but above it is within. So the lesson that we draw here is that you cannot just... Oh, that's much better. You cannot, therefore... Stay there. Stay there. No, sit there for a while. I'm now going to move on and to mention very briefly an issue which is going to be controversial without a question. That is the draft contract code. Now, this diagram is supposed to represent goods on one side of the diagram, land on the other side of the diagram, personal obligation on one side of the diagram, and property law on the bottom side. And the tick in the top left-hand quadrant indicates that if you are going to harmonize contract law at all, that is the scope which the contract law is going to cover. The cross in the bottom right-hand part of the diagram indicates substantive land law, and that is the part which I think is never going to be European in scope. The question, therefore, is the two question marks. Should you take into account property in goods? Should you take into account personal contractual obligations in relation to land? And somewhere along the two axes of that diagram, you have to draw a cut. English law, on the whole, will make the vertical division. It has a land law and a non-land law, and we can very easily draw a line down the middle of that diagram. Civilian systems, on the whole, have property law and a contract law completely separate, and so they would, on the whole, want to make the horizontal cut across the diagram. And as Seth was indicating earlier, I think, it is very difficult to reconcile those two systems. Having said that, most English academics, I think that the contract proposal is dead in the water, that there are problems of competence there. But that may be an English perspective rather than a European perspective. I'm not going to say very much about the mortgage proposal because I absolutely agreed with everything that Chef said about it. Mortgages are different from land because they can move. They can move across borders, and so mortgages are much more likely to be in the European domain than is a straightforward purchase or sale of land. The idea that was driving the European proposals in this field, as Seth was indicating, was the idea that a bank should be able to move its mortgage book. And that therefore implies that you should harmonize the way that mortgages operate, but it leads you into a whole spiral of the kind that Seth was talking about, where you need to harmonize the enforcement of mortgages, the registration of mortgages, and you get into more and more harmonization to try to realize this vision of having a common mortgage which is easy to transfer. And I personally think that this is going to be difficult. My own book, I think timing is the vital issue in all proposals in Europe. My own book was published just before the credit crunch, and it therefore takes a fairly gung-ho approach to how there's going to be a development of a mortgage market, whereas the reality, the political reality now, 4 years afterwards, is that it has been pushed back a very long way, I think, this discussion of this issue, by the fact that basically the Germans do not want British debt. And the common mortgage market is British banks selling debt to the continent, which may not be a good thing. Well, the next slide was going to pick up again very much on something that Chef was talking about, but it's also going to, I think, lead into the discussions that are coming in relation to the registers. And that is this idea that registers do give you a form of harmonizing property law, essentially. Because registers all work in the same way, it is much easier to harmonize registration systems than it is to harmonize property systems. When I say that registers work the same way, I am assuming that there is a battle for survival of the fittest, that ultimately the German system is the fittest, the English system is pretty close to the German system, and that the French and Latin system is less fit. The German system registers title. The French system registers deeds, but does not give you a single snapshot of the current state of the title. The fact of the matter is that English law has had both, and the deeds system was rejected as totally useless in the long run. And I believe absolutely, we're talking 50, 100 years in the future, that there will be a register of title system, that is the fittest system to operate. If so, then I think it becomes much easier to harmonize property law without making it the same. You can have a place in the register to put mortgages without having mortgages the same in France or Spain or England or Scotland. You just need the presence of security rather than the actual security right to be the same everywhere. And so I think, as I say, that registration is the practical way in which harmonization will occur. Well, I think the crucial thing which is going to drive European property law is the internet. We've got two professors at Southampton. One of them is me, I'm a professor of law. I have a message on my email begging students to send me emails about property law. The other one is Sir Tim Berners-Lee. He's not really a professor at Southampton, it's his kind of second job. He has a message on his email which says, please don't send me an email, particularly if it's just because your computer's broken. But what a powerful tool he created in the internet. What on earth would the vast majority of employees do if they didn't have the internet to play with all day? I'm going to suggest that the internet is the key tool in purchasing land. I've got in my property portal 3 clients. The first one is Rational. Well, Rational accept that they're buying in Valencia, which might not be a particularly wise or rational move from what we've heard earlier. But this is rational in the sense that they choose where they want to buy first. And the logic is, therefore, that you have a national property system. The second one is Helen's method of purchasing property, which is to set out some completely bizarre criteria which have no relationship to a nation at all. Her primary criteria is that it should be completely impossible for her cats to be run over. And she therefore wants to be at least a mile from the nearest busy road and probably quarter of a mile from any road whatsoever, which reduces the scope for buying a property very considerably. She adopts the method which former poet laureate Ted Hughes in England is supposed to have adopted to buying property, which is to find a property that she likes, buy it, and then work out how to pay for it afterwards. This is a mechanism for bankruptcy, as you can imagine. And the third client is a general second home buyer, which is basically, they have exactly the same profile as golfers, and therefore having a golf course close to the property is the basic thing. They're not buying in Spain or Croatia or whatever, they're buying according to some criteria. It's that fact, the fact that people will not necessarily be buying in a particular property, a particular country, which opens up the potentiality of Europe-wide marketing. Well, Bram has mentioned capital movement as a crucial factor, clearly, in the drive towards European property law. And we have the EEA 30 as the basic area in which capital can move. One point I want to draw out here is you can see Switzerland in the middle there. They are outside the EEA precisely because they do not want people buying property in their country. That is how important this is, and it's therefore showing, to flip that over, it is showing the potentiality of capital movement. It really is that important for a major country to keep out of the system for precisely that reason. I suggest in my book that there is another Karl Marx writing away in St. Pancras somewhere in the British Library, and he's writing Das Kapital, only this time it is the free movement of capital to buy second homes elsewhere in Europe. It really has got the potential to change the face of Europe completely, has changed Spain, and has the potential to change the continent of Europe completely. Is there a correlation between these two examples? A Spanish buyer buying a property in Spain, or a British buyer buying a property in Spain? Now, if you take the view that this is primarily national markets, then you take the view that the things on the right-hand side of the screen are the things which are most important, that this is a transfer, a register with Spanish property law and Spanish notaries. If, however, you look at this as a cross-border interest, then I think...
Can you move nearer to the mics?
Sorry. If you take the view that this is a cross-border transaction, however, then you will take more attention to the payment for the property, the contractual arrangements, and the problem, I think the real problem of market surprise. The real problem is not understanding the property law. It is understanding what the property law doesn't tell you, but which you wish to know if you buy in Spain. For example, that the inheritance laws are completely different and you need to deal with them. Well, we heard slightly controversial statements from Bram and Chef about the scope of European integration and the Property Shield article. This is my controversial section. Notarial services are compartmentalized. It's deeply ingrained in the treaties that notarial services are national monopolies. If you want to break down the problems, then I think you have to have a European conveyancer. Now, this is not going to happen overnight. No one would believe that the notarial professions are going to give up their monopolies overnight and so on. But in the long run, I do believe that it is in their interests to move towards a European market. that there is a huge volume of business, and I do believe it's more particularly in the interests of consumers, clearly. And when I was in practice, which I think is probably just about the same time as Diana was, we assumed that high street conveyancers were safe forever. Soon afterwards, Mrs. Thatcher was elected, the high street monopoly disappeared, and now the market in England looks very, very different indeed. And I think the same thing will probably happen in Europe. I think much more, I personally didn't agree with the observations from the Maastricht speakers about the competence in property law. I think they probably know that I don't agree, it's just a difference of opinion. But I do think if you look at the United Kingdom, you do see the prospect of a soft harmonisation occurring. We have a system in which Scottish property law is separate from English property law. This was entrenched in 1801, I'm told, and has not really moved at all since. The two systems are completely separate. And yet, if you look at recent developments, you can see a move towards a common British Isles property law with changes to the Scottish Register. Irish land law has moved in line with English land law. And I think that that is possibly a more likely method of movement forward by groups of countries harmonizing their laws because we know more about each other and therefore the laws become more similar. But that does not address the problem which Seth was talking about of bringing together French law and English law, or bringing together German law and French law. And in particular, as he was quite rightly saying, the Scandinavian systems are completely different. By way of summary, therefore, the pink areas on this diagram are the ones where there might be some movement, where it is possible that European interest in land law will gradually expand. At the moment, the top line, the European law that Bram was talking about, is important but narrow. There is the potentiality to widen it, and in particular, if conveyancing services become, or if we do have a European conveyancer, then that could become wider. The bottom line is the things which, on my more restricted view of property law, European property law, are things which are basically national forever. And this diagram is very misleading because the bottom line there is huge, whereas the top line is basically rather small. But finally, I think this seminar has been wonderful in raising awareness of an issue. My book quotes Diana's speech at Munster several years ago on the issues. Very little's happened since, but I think this is a really important issue, as the Spanish speakers have shown, and I think it will increase as time goes by. I'm very grateful for being invited.
Thank you very much indeed. We're now really getting to see some of the possibilities and many of the difficulties. And now we're going to hear a voice from real practice. Welcome to Andrew Walker QC, who's going to tell us, I think, about some of the cases that you've had to deal with on behalf of European citizens.
Thank you, Diana. I hope you'll forgive me if I move away now from the debate on EU competency and the politics of all this. I'm sure Bram and Seth will forgive me if I describe myself as an immediate realist rather than an academic. I think if I were to just be said to have themes, they would be accessibility, transparency, and enforceability. I come to this debate as essentially a property lawyer and a property litigator. I also litigate in professional negligence disputes, so I deal with problems when they go wrong and professionals are at fault. But throughout that, what I'm always looking for is what are the problems and what are the solutions to those problems or ways of avoiding those problems. My clients don't thank me for thinking sort of too theoretically or looking at ideals. They want answers. And I suspect that that's something to which most EU citizens would relate more closely than debates about the technicalities of the law. And if I can just say one thing about a broad EU property law, I wonder whether that's a solution to any particular problem. There may be other reasons to proceed with it, but I don't see it as necessarily a solution. From a practical point of view, whatever the law is, there will always be cases where it's difficult to apply. It doesn't matter what the law is, whether it's an EU law, English law, French law. In reality, I think we have to wrestle for, at the very least, many years with any deficiencies in laws on a national basis. But in practice, the vast majority of problems aren't with the underlying law, they're with what people have done with it, with failures to enforce the law, or perhaps difficulty in enforcing it, or the way in which someone is trying to use it. The one area where there might be some role, one might say, for an EU property law that's been touched on was touched on at the very beginning of our seminars, the question of retrospectivity. Some of the problems, it seems to me, that have been suffered in Spain are nothing to do with the existing law or indeed with protecting citizens in advance when they enter into transactions. They're to do with the actions of governments and legislatures. If it's right that the Human Rights Convention does not provide an answer to that, then query whether the European Union conventions can provide an answer to that as well. They seek to take the same line, and the line that's been taken politically consistently is that governments, states are entitled to expropriate rights, but if they do, they must provide proper compensation. There's no or very little, I'm sure I may be corrected by Bram and Sepp in some respects, but there's no real precedent for preventing states from taking action to remove property rights. So this is a political issue as much as anything else. This, it seems to me, is an issue where the European Parliament in particular can bring very strong influence to bear, but it is political influence for me, rather than influence involving legislation or any particular political action. And I think that is, in practice, likely to achieve a much greater effect. Constitutional guarantees are what we're really talking about here, rather than a pan-European land law. So much for the law of the land as it is. There are three areas I want to touch on briefly from a practical perspective, and they concern transactions. There are really three stages that I want to look at. There's the first stage, the plugging the information into the internet and up pops your particulars for a particular set of property. What are you being told at that stage? That's, as it were, the initial interest point where you're told lots of wonderful things about the property, some of which may not turn out to be true. The EU has already been active in that area. And I know that member states have been active in that area. We had a statute back in 1991 called the Property Misdescriptions Act, which made it unlawful for those in the business of selling properties to make inaccurate statements about a whole host of things, not just to do with title, but to do with things relating to the property, such as planning and rights and so forth. That activity seems to me, as I agree with Peter here, to have got to grips with the problem. And I would be very cautious about any more action there until we've actually seen whether that works in practice. We need to give those enforcing, or the rights to enforce that sort of legislation, time to begin to understand it and to try to find sensible ways of enforcing it. That seems to me to be the right approach. There's then a second stage, though, and that's the stage of entering into formal legal relations. That's the point where consumers, and indeed anyone buying property, needs to know what it is they are buying. And it does seem to me, from what I've seen in practice and from looking at some of the slightly different tales from Spain that I've seen, that it's not always a question of retrospectivity we're worried about, it's a question of a lack of information. And that's where the questions of accessibility and transparency really do come to the fore. The important thing, it seems to me, is for people to know what it is they are buying and to know what risks they are taking on. If information is not accessible, or if administrative, whether that's legal or public bodies, systems are not transparent, then people will not know what they're buying, and they will not know what risks they're taking on. Now, this clearly has a cross-border flavour, because as Peter's mentioned, if you're coming from one member state buying in another, you bring with you certain assumptions. You won't know very much about the law, probably your own home member state, but you'll bring with you some assumptions about what you think the rules will be that apply to your use of the property, and broadly what's involved in buying. Those assumptions may not hold good in a different member state. But this is, and it's clear from the comments we had right at the beginning, this is not just a cross-border issue. This is an issue for citizens of member states buying in their own member states. Whether there's EU competency or not, in a sense, is neither here nor there, because if there's a problem, it requires a practical solution. And again, political pressure could be brought to bear to seek to achieve that. It strikes me that the practical solution there is rather along the lines of what we're about to hear from Gabriel about the European Land Registry project and certain other projects. I'm always wary of grand schemes to try to harmonise everything from the centre and get everything all in one place. But it does seem to me that lessons can be learned by all member states from others about how to provide information, make it accessible, and how to administer things in a transparent fashion. I mean, the classic example of these that I come across often is in planning law. Every member state has different rules about what one can build and how one can use property. In England, we have particular rules for what are known as listed buildings, buildings of particular architectural or historical interest. We have much tighter restrictions on those. I have clients from outside England who have bought properties without being aware of that at all. Now, there may well be a failing on behalf of their lawyers in that respect, but there's a failure to appreciate something which they're just simply not familiar with because they have no experience of something of that nature. The same may apply, I suspect, in some respects in Spain. If you have a complex planning system with several layers, and it seems in some of these cases that the planning has been okay at one layer but not at another, you need to understand the existence of those layers. And the only way in reality you're going to do that is by having a lawyer who knows about the local conditions. So I noted Peter's suggestion of a Euro conveyancer. Well, maybe there will be a Euro conveyancer. I tend to think it'll be slightly more narrow, perhaps, in the future, that we will have cross-border conveyancing, but it'll be carried out by people who do understand the local conditions. I don't see how you can sensibly deal with conveyancing of a property in another member state you can't even see. You don't know where it is. It might have a massive hill behind it. If you're looking to protect your client's interests, you need to know about it. You need to know about local geographic, cultural, social issues, not just the legal issues. But the way to try and address that as much as anything is by having systems in place which enable you to get that information. Well, from an English perspective, our conveyancing is all about questions and answers being raised with public bodies, private bodies, the other party to the transaction. There are some standardized procedures, standardized documents that provide some consistency and that give all those who are buying and selling some confidence that the right questions are being asked, and indeed for sellers, that they're being asked questions that are entirely appropriate. It also enables everyone to know what has been said. In a number of the cases I've seen in practice, and I've seen in Spain, have involved promises being made that have not been kept, but there may be no record of those promises. It's all just chats over the telephone, handshakes, discussions on site. The important questions need to be asked and the answers recorded. Our system enables that, and that's a practice that I would expect as a client to see elsewhere in Europe. I'd want to know exactly what it is I was entitled to rely on when I'm buying a property. So for me, having systems in place for conveyancing and systems in place to enable people to get access to that information, the information they need, is critical. If the EU can bring either pressure to bear where there are particular problems, or can encourage and fund projects such as the European Land Registry Association projects, that seems to me to be a practical solution to real problems that are being suffered, and one that could work in a relatively short timescale. The other aspect of all this is enforcement. At the end of the day, property rights do need to be enforced. And again, it doesn't matter what law we have, whether it's an EU law or a national law, there needs to be enforcement. I am horrified sometimes at how long cases take to get to court. Sometimes happens, I have to say, in England and Wales, in my experience, for a mixture of reasons. But my understanding is in some member states it can take very much longer indeed for cases to be tried. Again, this is something that's perhaps outside EU competency, but it is fundamental. If you're talking about law, enforcement of the law has to be available. And that means public authorities need to be active in enforcing the law where it's needed. But most importantly, the judicial systems of the member states need to be available, and available in an efficient way. If political pressure can be brought to bear on member states where there are problems of that nature, that also strikes me as much more likely to achieve a satisfactory outcome than trying to harmonise law, because there's no point having a law if you can't actually get a result in a sensible time frame. So from my perspective, my theme, I come back to those themes: accessibility and transparency for transactions, and enforceability at the end of the day. Whatever action should be taken should follow those three themes.
Thank you very much. I can't help remembering that when I was quite a young solicitor, I dealt with conveyance, and for various reasons I'd actually been and seen the property. And then there was a query raised by the land registry when it had to be registered, and a gentleman from the land registry rang me and asked me about it, and I was able to describe in great detail the front of this house. And he said, "I don't believe it. A lawyer that's actually seen the property they're buying on behalf of a client." So you reminded me about how much more difficult would that be if we're talking about cross-border conveyancing. But it's true. It's actually that knowledge and security that our citizens deserve. So thank you very much for that, because the next thing that we're going on to, as you rightly said, is to look at the European Land Registry and whether registration will assist us with providing that security, which seems so all-important and may provide the practical way forward. So if I can ask the next two speakers to join me up here. The Secretary General of the Land Registry. Welcome.
Thank you very much.
The floor is yours, Mr. Landetta.
To present its projects in this seminar. Legal certainty in property rights is a matter of much concern for land registry. I try first to present my association. ELRE stands for European Land Registry Association. It's a non-profit association seated in Brussels. It's supported by the European Commission through the Programme of Civil Justice. ELRA is made up of 29 national land registry organizations from 22 countries of Europe, and the basic aim of ELRA is to promote mutual understanding and the knowledge of land registry, stressing the legal aspects. I will try to separate my presentation into 3 blocks. First, I make a broad picture of what is land registries and what is the actual situation of land registries in Europe. Then I will move to the project that we are developing called Crobeco on the acquisition process of ownership. And finally, I will more or less deal with these drawbacks that have been expressed here regarding the public restrictions. I have to say that the acquisition of ownership means a very important moment in the lifetime of the European citizens. Normally, property immovable represents the main, it has been said already here, investment of a European citizen in life. And for that purpose, state, in specifically European states, considers this process as a matter of public interest and also provide essential services for it, considered as public services. But I have to say that the state does establish rules for protecting this process and also for protecting these property rights. Real rights give the holder a direct exclusive power over immovable property, power that is enforceable against all. It is effective erga omnes, and therefore it must be made public so it can be known by all. Public disclosure is provided by this specific institution, which is the land registry. So land registries are not simple databases. Registration publicity is not mere information, but qualified information, information with legal value and effects. Publicity is a prerequisite for the absolute efficacy of the real rights. So we can say that in some systems, registration forms part of the conveyancing process and actually determines at what point in time the right is acquired. And certain rights, such as mortgage, are created only at registration. If we want to analyze the action of land registries in the European area, account must be taken of the following characteristic factors. First, in each state, land registry occupies a different location in the state structure. This disparity in the institutional framework makes any pan-European coordination of land registries very difficult. We can see how in Germany land registry depends on the courts of justice, other systems depend on the administrations, other systems create land registry as independent governmental agencies, so to coordinate the action is quite difficult. Second characteristic is land registry are very closely linked to the principle of the lex resita, and they are governed by rules deeply rooted in national legal tradition. And last, and most perhaps important, is that although all member states have land registers, I have to say, and has been said here before by Peter, that not all land registries provide the same effects, and they don't dispense either the same degree of protection. We have, in broad terms, to distinguish what we call the deed system, which is a system where they are restricted to filing and publishing contracts. Registered contracts prevail over unregistered contracts, but the registry does not guarantee a buyer's right. This is what is called the negative effect. And on the other hand, we have the title system, or registry of titles, which directly registry property rights. The registry deploys here the greater effects, which is the protection of the right for any purchaser in good faith. It's called the positive effect. These title registration systems complies with the 3 principles inspiring the most effective registration systems. The mirror principle, which means the title disclosed by the registry faithfully reflects legal reality. The curtain principle, rights in a registered property that are not themselves registered are left out of the title. And the insurance principle, the state guarantees the accuracy of the registered title. We have to say that title system can provide legal certainty within the single market because it enables contracts concerning ownership rights to be made anywhere in the European area. All that is needed is a simple inquiry, and the registry, backed by the state's guarantee, reports on the legal situation of ownership rights. There is no need to search for rights in an unknown system of another country. After having this general overview of how the land registries are in Europe, We're going to focus on a specific project we are dealing with in our association, which is the Crobeco project. When a European citizen wants to buy a piece of property located in another member state, besides the increased expenses he must bear, he also must deal with the ignorance of the language, ignorance also of the legal system he's operating in, lack of important legal information at the contract's conclusion, such as public restrictions, I will see below, and ignorance of the registration system, which makes it harder for him or her to protect the rights through registration. Supported by the European Commission, a European project has been initiated known as Crobeco, Cross-Border Electronic Conveyancing. This project implemented aims to establish simple and more confidence-inspiring process for obtaining immovable property abroad. Crobeco uses possibilities offered by existing secure communications and electronic authentication systems, standardized multilingual forms, and instruments offered by the Union acquis in matters of civil justice. The purchasing procedure will largely be conducted electronically and settled in the buyer's home country. Foreign buyers often prefer the applicability of protective rules from the law of their home country, also because of the fact that the deed is processed in their own language and by a conveyancer from their home country, they get the feeling that they are better legally protected. It is important to stress that Crobeco is a project that fully respects the national systems in force. It does not attempt to eliminate requirements, but to meet all requirements its state's legislation established in order to produce effects. The project incorporates these ideals of respect for existing legislation, respect for existing technologies, and respect for existing responsibilities. The project tests the possibility of using the rules of Round 1 regulation to enable parties to exercise the right to choose the applicable law. The contract effects are therefore split between the effects that produce obligations between the parties and the in-rem effects of the contract. The choice of law is possible not only for contractual but also for non-contractual obligations according to regulations Round 1 and 2. But it's important to stress that law choice can only concern obligations of buyer and seller. Law choice can never concern the acquiring of property rights itself that are governed by the legislative city of the country of the plot. The law choice is established in a specific clause of the contract of sale and assures the buyer compensations for unknown restrictions and violations of the contract by the seller. When, for example, a Dutch buyer of a Spanish real estate agrees with the seller that the Dutch legislation is applicable to the contract, the buyer is entitled to a transfer of free and unburdened ownership. When he afterwards finds out that there exists unknown public restrictions, he could ask a Dutch court for compensation by the seller. Regarding the technologies, we must say that because of the fact that timely receipt of information from the land registry by the conveyancer and of conveyance documents by register is essential for cross-border conveyance, the framework will be based on electronic communications. The deed will be also an electronic document signed by the conveyancers with an advanced electronic signature. Crobeco is then developing a set of rules and protocols called Common Conveyancing Reference Framework, which is conceived as a toolbox. Work is being done with standardized bilingual contract forms containing the relevant contractual clauses for producing the effects sought by the parties in each legal system. Moreover, a checklist of protective clauses and guidelines for cross-border transfer of rights is currently being developed in cooperation with the Maastricht University's European Private Law Institute. As not all European conveyancing and land registration systems are the same, specific rules will be developed adapted for each system. Also, the ICT solutions differ in each member state, so Crobeco approach is neutral regarding the technology tools. It will try to fill requirements imposed by each member state, but always having in mind the European institutional developments in this area, either in the digital agenda and e-justice program. Pilots involving the obtaining of immovable property in Spain and Portugal via Dutch civil law notary are already launched in order to gain a better understanding of practical problems. Pilots with other countries will follow this year. In the Quebeco project, once the bilingual deed is signed, the electronic document is transmitted internally to the National Registry, which forwards it to the Registry of Destination with the addition of a statement of validity. The liability rule is not changed. It's a question of mutual trust. This process simplifies one of the main obstacles in cross-border transactions, which is the proof of the foreign law. The registry answers immediately, issuing a receipt of proof of the document was received and submitted for entry in the day list. Priority is thus guaranteed from that moment forward, according to the principle prior tempore potior jure. Quebeco will benefit from another ELRA initiative. ELRA has coordinated an action amongst its members for the creation of a land registry assistance network called the European Land Registry Network. The European Land Registry Network will support Quebeco project at two different stages of the envisaged process. In the very first moment, the network will help to provide the pre-contractual information, which is very important, as Andrew was saying. Registry publicity must be obtainable not just inside each member state, but from anywhere in the European area, using secure communication systems. We must say that the widespread introduction of ICT in registration organizations through Europe is a fact today, and a significant number of registers have now online inquiry services. European Commission is going to create a single European access point for registry information within the e-Justice portal by year 2013. However, it is important to remember that not all European registry information has the same inherent value. Therefore, it is not enough to facilitate access to registry information. In addition, for the system to be effective, it must respond to the problems posed by the linguistic barriers, lack of familiarity with the legal value and relevance of the information provided by each registry. The network's activity is deployed here at two different levels. At first level, basic reference information is collected in a simple, easy-to-understand language, explaining the contents and the value of registry publicity. The information will be posted on the Internet. But at a second level, individualized assistance will be provided by the network. The second moment where the network is important in this process will be in the very last part of the process. After the contract is signed and sent to the land registry, additional requirements must be fulfilled in the member states where the plot is located. And before the final registration is performed, some additional acts must be made, for instance, the payment of property transfer taxes. In this moment, the network will have also to cooperate at this stage, providing advice about the registration procedure and facilitating the compliance with these additional requirements involving national administrations. By means of this process, European Land Registry take a step forward and place the services at the disposal of the parties, notaries, and other professionals involved in the real estate conveyancing, accompanying them throughout the conveyancing process until the registry receives the transfer right and vests it with its system protection. Finally, I would like to have a short talk about this big issue that has been expressed here since the very beginning, which is the public restrictions. The social function of ownership is stated in most modern constitutions, and ownership is no longer an absolute power, but a set of powers that can be enjoyed only in accordance with the general interest. This public interest sets limitations of the exercise of owner's right in the form of restrictions on public rights. Identifying these public restrictions on real estate ownership in each country, in each region, in each piece of territory is the challenge that we are facing. No longer is enough today to know who owns a piece of real estate. It is also most especially necessary to know what the terms of the owner's right are and to what uses the real estate can be put. A balance needs to be struck between protecting the general interest and protecting the fundamental right to private property. With the kind of instruments we have today in our hands, transparency must be increased and measures must be taken to strengthen legal certainty against public restrictions. The following measures are suggested. First, very easy solution, each state should have to create lists of public restrictions pertaining to land. ELRA is already working on a research project in which its members are attempting to identify at least the major public restrictions and limitations in the different member states. However, this is just basic information. the restrictions generically anticipated in law must later be implemented by the administration in actual sectors of land. So individualized, easily accessed information for each property is therefore what is needed. Second measure should be a concentration of all the information concerning public restriction at a single point. Citizens should not be burdened with having to check with each administration about potential restriction on property they want to buy. With right technology tools, it is possible to set up a concentration points in each state to coordinate all information about these public restrictions. This point should be the land registry. First, because the registry is the legal instrument for providing publicity of ownership rights. Land registry publicity could become misleading. If ownership is acquired in good faith, trusting in the contents reported by a registry that fails to disclose a public restriction, the state can be held responsible for creating an erroneous appearance of a movable property's legal situation, and this case has been already stated by the European Court of Human Rights in several cases. And also this point should be the land registry for practical reasons, because all the purchasing process begins and ends at the land registry. For the purpose, the land registry should have to use the technological tools to process this information. And we can say that as land information can be put in a graphic form, a system for processing graphic bases could make matters possible. On a picture of land, each administration could draw lines around the areas subjected to restrictions on its part. Each area could be tagged with the pertinent information about the system of rules applied to it. Supplying registry with this information could be enough. Once the property is identified and located on the map, the registry can ascertain whether it lies inside any area subjected to restrictions and report the statutory regime to which the property is subjected. However, this information on public limitation would not have the guarantee or the effects of the registration publicity, because it would not be registered information. It could simply be a tip of notice alerting the interested parties to the basic circumstances and telling them which the administration to see for further information. We can see how the technique could be using different laps of information overlapping to each other. For instance, this is the case, a typical case of the ley de costas in Spain, and how could deal with this as pre-contractual information, providing information about where the lines set by administration have been set. We can see there, which is the line for protected servitude, where you cannot build on there. This is the line for public domain, obviously. You can also have the same information regarding the urban properties. Here you see again, which is the public domain, the line for servitudes, and so. But then again, a third level of much more technically complex protection could be obtained if an effort was made to integrate and coordinate public limitation within the system of land registry publicity. This would enable the interaction of public restriction with ownership rights and other rights in property to be delimited. We can say that public and private law interact increasingly these days, and their interaction constitutes a defining trait of modern property rights. That is why it's necessary to work out solutions for re-establishing legal certainty. As a conclusion, in the view of the breakdown of legal certainty in international real estate transactions, European land registries assumes the responsibility to enhance confidence, becoming an effective instrument for the integration of the single market at the service of European citizens. Thank you.
Thank you so much, especially for giving us, I think, some practical food for thought about what I think really could help in the future. But now we turn to Mr. Xavier Ibaronda, who's a practitioner and again has dealt with cross-border property issues. The floor is yours.
Je vous remercie.
Thank you very much. Ladies and gentlemen, I'd like to begin by thanking Mrs. Diana Wallis, Vice President of the European Parliament, for giving me the opportunity to present the point of view of a practitioner. Before looking at some concrete examples of my daily practice, I'd like to present the Eurojuris International and Eurojuris Belgium associations. I'm the Vice President of Eurojuris Belgium. Eurojuris International was established in 1980 across Europe and is the #1 group of European lawyers' chambers in today. It's present in 610 different towns and 18 countries. Each of these countries has a national Eurojuris association comprising medium-sized independent lawyers' chambers. For example, my chamber in Nivelles has 23 lawyers. In all these countries, the cabinets have to satisfy selection criteria, particularly relating to quality. There's an ISO type approach for most of them. Eurojuris also works with several cabinets throughout the world. But the goal is to give companies, public authorities and individuals direct legal counsel and advice and local representation everywhere in Europe. The members of Eurojuris International meet twice a year to take part in specialist practice groups, particularly with regard to property law. The members from each country meet to discuss the issues going on in each country and exchange on their daily practices. So, the main issue that emerges at the moment is how to purchase property in Europe, and we have to respond to the difficulties that emerge for our clients. I will deal with this issue in 4 points. The first relates to the difficulties relating to the diversity of legal systems and concepts linked to property rights in Europe, and we've heard a great deal about that this morning already. The second difficulty relates to those acting in the field, notaries, lawyers, estate agents. Their status and powers can vary from one state to another. Then I'll tell you a few practical examples, and I will conclude by talking about the initiative of our Spanish eBedjuris network, which has established a particular a system relating to this issue. So with regard to the first difficulty, the divergence of legal systems, I won't go on about that at too great a length. We've seen this morning how systems can be different and the interest that there would be in finding harmonised and common solutions that respect the traditions of member states. Consumers usually face an information deficit linked to the property regime in its widest sense, and here we're talking about ownership, co-ownership, rent financing, long-term leases, time-sharing, usufruct, etc. There's a lack of information focused on the tax regime relating to the purchase of property. We haven't had a great deal of about this morning, but this is an important issue. And also relating to access to credit in the country concerned. This is a major obstacle to the cross-border purchase of property as well. We know that the European Commission wants to avoid discriminatory tax measures that may exist in various states. There is an example in my notes. The Commission took Greece to the Court of Justice in 2009 because of discriminatory fiscal provisions that applied to the purchase of a first residence in that country, and they also took Germany to the Court of Justice as well for tax issues. Now, the complexity of the issues can cause problems for professionals, so you can imagine how consumers must feel. The problem is that there is no clear and reliable information source that would enable us to have an idea of the different legal systems in force. Things are even more complex because in each state there can be civil law rules that vary between regions. For example, in Spain, where communities can legislate on this issue depending on their degree of independence. It's also the case in Belgium because rules can vary between regions on registration law and inheritance law. Now, for practitioners, the main issue that raises its ugly head relates to which law actually applies, then the core issue of the court having jurisdiction and the recognition and enforcement of the decisions and deeds of ownership in the member states in question. I won't go back to the first issue. Others have already spoken about that, and I'm not an expert on that issue. I'm not a university professor, so others have spoken much better than I could. But with regard to the practical aspect, i.e. the court having jurisdiction and recognition, well, we do have a European tool available, because Council Regulation number 44/2001, known as Brussels I, is the instrument that governs the attribution of international competencies between member states of the European Union, and the conditions and methods of recognition and enforcement of judgments given in member states, as well as that relating to deeds of ownerships. In most member states, this convention replaces the 1968 Brussels Convention, or agreement. There are two important articles. Article 22 of the regulation is important. It says that regardless of domicile, competence is only held by the courts of the member state where the property is located, and issues relating to property rights and leasing of property. Articles 38 and following of the regulation state that decisions taken in a member state which are to be enforced need to be enforced in another member state after having been declared as enforceable on the request of all interested parties. And we earlier heard about the slowness of justice. I think this is a problem across Europe. Our legal system is not too hasty, thank God, but the fact is it is often very slow, particularly in Belgium. I did read in the papers this morning that the Belgian law is pretty good, but for example, when you have to wait 7 years for the Court of Appeal to deal with a simple issue, I don't think we can say that it's particularly effective legal system. But anyway, and the other second article is Article 57 of the regulation, that deeds of ownership recognised and enforced in one member state are on request declared enforceable in another member state pursuant to the procedure envisaged in Articles 38 following. These tools are extremely important and precious for practitioners, and I'll come back to those in a little while when I talk about practical cases. Now, another difficulty in relating to this issue relates to the professionals involved, their competences and their powers, because these can vary between member states. In Belgium, the notary is the main figure who authenticates property contracts, but we know that this system doesn't exist everywhere in Europe, and the role of a notary can vary considerably. We know, for example, in France, it's lawyers who carry out public sales of property, whereas in Belgium it's a notary. So you can see the systems are different. I'm not a specialist of the legal systems of all European countries, but I've kind of raised issues that I instantly see as causing problems. Now, for consumers, the main issue relates to access to information. This is the main obstacle, particularly if we add the issue of language, as Mr. Alonso Landeta was saying. You can imagine this can be very tough. And of course there is the status of estate agents and the various professionals involved, which can change from country to country. It's the same issue relating to credit rules. These are often a major obstacle, and I won't mention the guarantees that purchasers often need to provide when they're buying a property, and this can also vary depending on the country in which they are. I don't have time to deal with all of these issues, but I will briefly come back to some of these in my conclusion when I talk about the experience of EBA jurists. Mrs. Wallace wanted us to give practical examples. So, in all modesty, I will give you 2 examples, I could have chosen others, that enable me to demonstrate some of the difficulties I have found, or that my clients have found, in practice. First case relates to an Italian company which decided to rent a building in Nivelles, the town I come from, which is near Brussels, and they rented it from a Belgian company which owns the building. Now, the Italian company's business didn't go well, so they decided to leave their Belgian property, and they literally abandoned it, leaving the owner with a pretty heavy bill. Now, the Brussels I regulation meant that the dispute was taken to the Nivelles Justice of the Peace, because that's the building is located in Nivelles. The decision was reached, and the decision needed to be enforced in Italy. Now, I told you that the Belgian legal system is slow, but sometimes you find that other systems are even slower. Although the fact is that I managed to get a decree from it took me a year to get the Court of Appeal of Florence to say that the Belgian decree was valid. And let me remind you that all they had to do was basically say whether it was actually a Belgian judge who'd given the decision and whether it was valid. So the main difficulties in this example came from the fact that the Italian company didn't attend the hearing in Belgium. We know that they're within their rights not to do that, but perhaps we should simplify measures relating to that. So how legal notifications are made to the various parties involved. But basically the main problem related to recognising the decision from the Belgian courts. The Eurojurist network enabled us to take an interesting approach here, because rather than basically handing over the Belgian decision to my client and saying, well, now you get on with it, you go and deal with this in Italy. But rather than doing that, we were able to offer the client continuity by sending the file to my counterpart in Florence. So networking enables us to deal with one of the main obstacles faced on these issues, because we managed to simplify the ways in which information can be accessed and access to justice for the citizen of a member state when a decision needs to be enforced in another member state. This communication and this access to information enables us to promote and guarantee exchanges between companies from different member states. If this wasn't possible, the legal maze that the company in question would have to go through may well produce a significant block on investment and contracts being signed in various member states. The second example relates to a Belgian who had purchased property in Spain. His wife was Belgian as well, and they were married under the regime of shared ownership of goods. But they hadn't. He wanted to sell the building, and he hadn't got his wife to sign the sales contract. When he got home, he found that his wife wasn't particularly. The purchase contract. When he got home, he found that his wife wasn't particularly happy with this purchase of property in Spain, and so the cancellation of the contract became the issue. Under the Brussels I regulation, the dispute comes under the jurisdiction of the Spanish courts, more particularly the Court of Figueras. Now, the major difficulty in this kind of issue relates to checking the solutions that apply in Belgian civil law and checking whether they're compatible with Spanish civil law, and more particularly with Catalan civil law, because there are specific rules relating to the purchase contract in Catalonia. Spanish law is essentially compatible with Belgian law in this, because the agreement of the spouse is essential in under both legislations. But you can imagine, for example, if the dispute was over the value of the property and it's being overvalued, the solution wouldn't have been so simple, because the rules on annulment on the grounds of misrepresentation are very different in the two countries, in spite of the fact that we have relatively similar legal bases in Spain and Belgium. Now, practically speaking, the fact that we had a network of professionals working with the same vision and in accordance with the same quality standards, enabled us to anticipate these problems and sometimes enables us to avoid court cases. And that was the case in the example I've just given you. Let me give you another example, that of a Belgian family whose parents married under the regime of shared ownership, and they had purchased a flat in France. The father died, and the family had to deal with issues relating to inheritance and transferring the property here as well. The issue is relatively simple. I haven't had to deal with UK law yet, and that may be more complicated, but French and Belgian laws are very similar. And the solution was that the widow inherited usufruct from the husband, whereas the two sons inherited the underlying property rights. Obviously, we still had to deal with issues relating to inheritance tax, where and to who should this be paid, and also issues relating to amending the title deeds. Here once again the Eurojuris network, which in France has over 650 members, enabled us to come up with a pretty rapid solution to this, and in particular gave us information on the issues pretty rapidly. Now, let me conclude by giving you the example of the ALDEADLE network. This is basically the Spanish branch of Eurojuris a few years ago. Given the concerns over the situation of property in Spain, they took the initiative of establishing a specialised group on property law with the objective of sharing and exchanging knowledge on property law in a professional and practical manner. At the same time, the lawyers who were members of ALDEADLE decided to standardise their legal consultations and services relating to the purchase and sale of property in Spain. They came up with a practical guide, including the services necessary to safely complete the purchase of a property in Spain. And this involves, they believe, checking not only whether the property is properly registered, but also looking at urban planning rules and local building laws, as well as carrying out a study of the financial and tax aspects of the transaction. Based on this guide, the lawyers of ALDEADLE will, when consulted, follow the points on the checklist. And I have listed the points they make in their checklist in my written contribution to this hearing, and they obviously adapt their practice to the specific case. Now, of course, you have to take a pragmatic approach in these cases. You have to be flexible, but I think the ALDEADLE example is an excellent one, and all of us should have, in each member state, should have a local network which would, and also we should have a checklist which would mean that we could predict the main difficulties linked to property purchases. I believe that we should have this practical tool in every member state, and perhaps we could draw it up while working with your Parliament. Thank you very much.
Thank you so much, and clearly some other practical suggestions. I have to confess we're up against the clock now, but there are some things that I would like to say. First of all, I'm very grateful we have a representative from the European Commission here from DG Justice, Mr. Petrie, and I know he has been listening and scribbling away all morning. So if you would like to take the floor briefly, I give you the offer, but that we are under pressure.
Thank you so much, Mrs. Wallis. And I have no problem with being brief. But indeed, it's been a very interesting seminar and morning for me to listen to these various aspects of a problem that is, I have to say, very well known to the Commission services. We do receive regularly letters from citizens concerning problems with property acquisitions and property ownerships in countries other than their own or where they come from. Spain is one of the countries concerned, but not the only one, it's clear. Cyprus is another one, a country that has been mentioned today. Now, various issues are raised in those letters, And of course, the first thing that we do when we receive one is to look at it and to see whether really there is an issue of EU law raised in the context of what is put forward in the letter, or if it's not the case. Very often, it does indeed deal with the situations as described this morning about public restrictions imposed by public authorities on the enjoyment of property, sometimes retroactively. And in that case, the conclusion is that there is no specific EU legislation which applies, and also, unfortunately, that the Charter of Fundamental Rights cannot be invoked because there is no link to EU law. What does then remain for the citizen is to invoke, as has been explained already, the European Convention of Human Rights. Now, however, there are also situations where we can see that there is an issue of EU legislation raised. I come from within the Justice, the unit responsible for consumer legislation, and here sometimes indeed citizens complain about unfair practices carried out by property developers. That arises now and then. And there we do have indeed the Unfair Commercial Practices Directive, which is in place since a few years ago. And there is then an EU legislative framework within it is possible to act. However, again, the issue there is then most often an issue of enforcement of the legislation against, in this case, the property developer, a private company, which is a member state competence. So from the Commission point of view, what we can do then is to perhaps write to the member state in question and make sure that the issue is followed up by the competent enforcement authorities. And I mean, the possibility of the Commission to act against member states in relation to infringement procedures is limited. That would have to be for the Commission to prove in those situations that actually the member state authorities have failed in there, and that there is a systemic failure also in enforcing the legislation in question. So that is a little bit what we can do under the situation of the present law. I mean, the different interventions have explained in a very good way to what extent the legislation applies. We have the timeshare directive. I should mention, this has not been mentioned today actually, but we do have in negotiation right now, hopefully at the end of negotiation, the consumer rights directive, which would replace the distance selling and the doorstep selling directives probably. But as it looks now, the most likely outcome would be that the unfair contract terms and consumer sales directives remain in place. In any event, the consumer rights directive, it looks like it would also exclude from its scope of application the acquisition or contracts concerning immovable property. Now, so what I would just say 2 words about what solutions to draw here for the future from our point of view. Well, I think listening to interventions this morning, there are fields of action where it seems difficult, at least in the short term, to do something. And that is, I would draw the conclusion about really substantive property law. There appears to be a consensus in the room. And also, I must say that I think that the problems explained this morning would not be solved by harmonization of substantive property law. Indeed, as explained by Mr. Walker, it is rather an issue of the constitutionality and the possibility to invoke the European Convention of Human Rights. But I do, however, look upon with some optimism about the project run by the European Land Registers Association, which is indeed supported by the Commission, and the Quebeco project, which we support and we think is an excellent project. And the mention was. The e-justice portal was also mentioned today, which I think in various areas of law will be an excellent tool to really bring together access points for information, and including land registers information then in different member states. And then one final word, the last speaker referred to the Brussels I regulation and the difficulty of getting judgments recognized. Indeed, the ambition of the Commission is to abolish the exequatur procedure when revising the Brussels I regulations. There, I do agree this is a problem. Thank you.
Thank you so much. Thank you again to all of our speakers. The intention is to provide some sort of written publication as a result of today. I feel we've been, as it were, on quite a long journey together, from our victims' stories to some options that will certainly not be possible for the short term, to some suggestions that may be possible to provide protective measures in the medium term, and a lot of food for thought. We have to vacate this room now, but if you go down to the 5th floor, we are providing you with some refreshments and the chance to discuss and continue to talk about these issues, which I hope you will continue to do both here today and in a wider dialogue in the future. But thank you all again for your participation.